Hello and welcome to NOFA Texas Estate School. This video is going to be to discuss who owns the property immediately upon death. Many people believe a house stays in a deceased person's name until probate is completed. Texas law says otherwise. The chapter we're covering today is Texas Estate Code 101.001. Under Chapter 101, ownership immediately passes to the heirs at law when a person dies. The court doesn't create the heirs. The court simply identifies who the heirs already were. Ownership passes immediately. That means the house doesn't sit around waiting for a judge to decide who owns it. Not 6 months later, it transfers immediately to the heirs at law. Not after probate, not after an attorney is hired. The moment death occurs, ownership moves from the deceased person to the heirs. The court is not created to create ownership. The court's job is to identify who the owners became. Once again, the court doesn't create ownership. The court identifies ownership. So even if dad died 10 years ago, that means the family became owners back then. This is not a question. So for example, we have John. John owns property yesterday, but John dies today. In the state of Texas, his family owns it tomorrow. That's the principle. Texas Estate Codes in Chapter 101. Ownership does not stay with the deceased. Ownership immediately passes to those entitled to inherit. To iterate, John owned it yesterday. John dies today. His family owns it tomorrow. The law has already moved ownership in Texas. So the key takeaways as we close: the dead cannot own property. Let that be the key statement, if anything. I'm going to repeat it. The dead cannot own property. The instant death occurs, ownership moves somewhere else by law. Chapter 101 tells us that ownership moves to the heirs or devisees. And we'll have a video to go over some of the words used in the law for those who are not familiar with devisees. Subject to the debts and administration. So let me repeat that sentence. Chapter 101 tells us that ownership moves to the heirs or devisees subject to debts and administration. Debts is a key word because, as you know, a mortgage is a debt, and we will talk about that. Only after that foundation is understood do we move to the next question. Who are those heirs? That question is not answered by Chapter 101 It's answered in Chapter 201, which we will also discuss. The next statute in Chapter 101 is 101.051. That section says the estate remains liable for the descendant's debt. That means you are liable for the debts on your parents' property, or your spouse, or whatever the scenario may be in the state of Texas. And what I'm getting to is a mortgage. Yes, your spouse or your parents qualify for the mortgage. Guess what? It's your mortgage to deal with immediately. Because back to the original key sentence, the dead cannot own property. Just because the heirs inherited the property does not mean creditors disappear. The property may still be used to satisfy lawful debts of the descendant. I'm your host, speaker narrator Jonah Wilson, co-founder of NOFA, estate advisor for the company in the state of Texas. We have years of resources and blogs on our website. Feel free to visit our NOFA Library. I want to thank you for attending this brief lecture. Today's lesson covered a simple but powerful principle. Ownership does not stop when a person dies, it transfers. To continue your education, please visit our website. If you're the state code yourself, the knowledge empowers the heirs. I hope this helps. God bless.